In this lesson, what I want to do is talk about the circumstances that are available for the courts when it comes to lifting the corporate veil or piercing the corporate veil. So we've noted over the last few lessons the idea of separate legal personality for companies in relation to the process of incorporation. Essentially, one of the things that distinguishes a company from a different kind of business, like a sole proprietor or a partnership, is the fact that once you go into and you incorporate a business, you create a business, you create a company, let's say, what you are doing at this point is creating something that has separate legal personality, something that is separate to you. And then when it comes to the idea of limited liability, what you are doing is you are creating an entity under which the debts for that particular institution, for that particular company, do not fall on you, the company creator or the company director, if that company goes into insolvency, for example. This is something known as the corporate veil. The corporate veil being essentially that liability is reduced and limited to that of the company, or that there is information and stuff going on that in relation to the company that is behind this corporate veil, okay, that is behind this ability such that the shareholders or that the director of the company cannot be held liable for debts or for actions committed by the company. Now, the corporate veil is a very powerful tool for directors and shareholders of corporations to essentially be able to take the kinds of risks that they might want to take, but with the added benefit of not necessarily incurring all of the liability of those risks. That's generally a good thing that we see. But sometimes there are circumstances in which the corporate veil needs to be lifted or pierced, and this lesson is going to talk about the concept of lifting the corporate veil, the ability to have a look at behind the corporate veil, if you will, and to sort of apply liability from which shareholders and directors might not otherwise be required to have said liability. So really, when it comes to the lifting of the corporate veil, there are sort of two categories that we will look at. Firstly is this idea of common law lifting of the corporate veil, the circumstances in which the common law has developed tests and developed procedures for which the courts may want to be able to lift the corporate veil. There are generally a few circumstances in which this takes place. We will look at this over this lesson and in the next lesson as well. Essentially, in this lesson, we're going to talk about the idea of circumstances involving fraud, shams, or cloaks. This might lead to the lifting of the corporate veil. We'll also look at agency theory as well in this lesson as a method by which the corporate veil might also be lifted. In the next lesson, we will talk about the modern approach, which is elucidated in the Supreme Court case of Prest. That will be what we'll look at essentially in its entirety over the course of the next lesson. So these are the sort of general circumstances in which the common law will recognize the ability to lift the corporate veil. So let's begin then. In circumstances of fraud, shams, or cloaks, essentially when the courts consider lifting the corporate veil on the grounds of fraud, or improper conduct, it might be, they will examine whether the company's structure or existence is being used in some kind of deceptive, fraudulent, or dishonest way in order for the people who are involved to essentially evade any kind of legal responsibilities. Now, we can understand the importance of the corporate veil on the one hand, but also, on the other hand, the importance that is attached to being able to lift the corporate veil in circumstances in which we are talking about fraud or shams or cloaks in that kind of way. A company may be regarded as a sham or a facade if it is set up with the intention to deceive third parties, to evade legal responsibilities, or to just generally perpetuate and perpetrate issuances of fraud. In such cases, the court will lift the corporate veil in order to hold individuals behind that corporate personality accountable for the company's actions. An example and illustration of this taking place can be seen in the case of Guildford Motor Corporation Limited versus Horn from 1933. In this famous case, we see Mr. Horn, who was a former managing director of Guildford Motor. He was bound by a non-compete clause. Now, what a non-compete clause essentially allows people to do or prevents people to do is preventing them from soliciting customers from his former employer. So sometimes this happens in various different circumstances in which you leave a company and you take with you a number of customers or clients from that company. If you have a non-compete clause in your contract, or you have signed a non-compete clause in relation to your leaving of a particular company, then that means that you are under an obligation to not solicit customers or solicit clients from that former corporation. Often that can happen in relation to quite large corporations in which you have various clients. So if you, for example, had an accountancy firm and you had a number of clients in that accountancy firm and you wanted to leave the accountancy firm and set up your own rival firm, if you had a non-compete clause in your contract or in your leaving deal, then you would be prevented from going after the clients that are in that accountancy firm and trying to take away business from them. To circumvent this clause, as you would probably imagine some people might like to do, Mr. Hall set up a company under his wife's name and instead solicited customers through that method instead. So instead of him directly soliciting customers, which would have been in contravention of his non-compete clause, he solicited customers through his wife's name, through a company that was set up under his wife's name. As you can imagine, you would see that the court lifts the corporate veil in this circumstance. They found that the company was merely a device or a mask which was used to conceal the breach of contract that was committed by Mr. Horn's conduct. The company was therefore treated as an instrument of fraud, and as a result of which we see liability be rendered onto Mr. Horn in relation to this particular case. An interesting circumstance we can see is with regards to fraudulent trading. Fraudulent trading occurs when a company continues to incur debts while the debtors or the controllers of the company know that there is no reasonable prospect of the company being able to repay said debts. So generally speaking, we know that it is a common part of corporation life and company life that we see the incurring of debts onto a business. That happens, and the payment of debts is obviously something that takes place over time. Where a company essentially is unable to pay the debts when they fall due, you have a situation known as insolvency. Now, we will do insolvency law in future lessons' time, but one of the things that can happen is if there is a continuation of trading under the company where the directors and the controllers know that there is no reasonable prospect of that company being able to repay any of the debts that are being incurred, then you are looking at a situation of fraudulent trading. And you can understand why certain company directors or shareholders might want to do this, because if they are under the assumption and under the perception that they would be protected through limited liability on these debts, then they can essentially incur as much debt as humanly possible with the knowledge that that will never be paid off, but also with the knowledge that that will never fall on them because of the corporate veil. Okay? If the corporate structure is used in this particular way, then the courts may be able to impose personal liability to those who are involved in this particular conduct. And in doing so, they will lift the corporate veil, they will pierce the corporate veil in that particular instance. There is a certain legislative agenda in which this is actually addressed. This is addressed under the 1986 Insolvency Act, specifically Section 213. Essentially what this does is it allows a court to hold any person who knowingly is a party to fraudulent trading personally liable for the debts of that particular company. We will get to this in insolvency law, and this actually represents not a common law justification for piercing the corporate veil, but also a legislative, a statutory justification for lifting the corporate veil. Along this similar line of inquiry, we can think about wrongful trading. Wrongful trading is similar to fraudulent trading, but where we look at wrongful trading, we're talking about sort of a less severe form of misconduct that does not necessarily require an intent to defraud creditors. Under Section 214 of the 1986 Insolvency Act, a director may be held personally liable for wrongful trading, again in piercing the corporate veil, if they continue to trade after they knew or reasonably should have known that the company had no reasonable prospect of avoiding insolvency. So it's a little bit less direct in terms of the intent that is required. So with fraudulent trading, intent to defraud creditors is a requirement. But with wrongful trading, we see that there can be the issuance of an order to pierce the corporate veil in relation to Section 214 of the Insolvency Act. This can take place in a circumstance in which the director of the company continues to trade, even if they either knew or should have known that the company had no reasonable prospect of avoiding such insolvency. It's not necessarily fraud, but it would constitute an improper conduct where the corporate veil would be pierced and the directors would be made personally liable for the debts that are incurred during this period of wrongful trading. Getting back on track then, getting back to the idea of common law jurisdictions or justification, should I say, for piercing the corporate veil, I want to talk a little bit about agency theory. Now, agency theory essentially tells us that the corporate veil may be lifted or may be pierced if the company acts as an agent or an alter ego of one of its shareholders. Now, it means essentially that the company is not genuinely acting as an independent entity as it should, and as it technically is on paper, but is really just acting as an instrument for the individuals who are behind it. And in that regard, then, we would see a circumstance in which you can lift the corporate veil in order to ascribe liability to the people who are essentially rendering their liability moot or limited, simply by reference to simply shielding themselves with this company. An example and illustration of this taking place is in the 1939 case of Smith, Stone and Knight Limited versus Birmingham Corporation. In this case, we see that Smith, Stone and Knight Limited, SSK, was a parent company. The parent company owned the land in question, a particular piece of land. A subsidiary to Smith, Stone and Knight Limited operated a business. This was a waste paper business on the land that was owned. So you sort of have two layers. You have a subsidiary and you have a parent company that owns this subsidiary corporation. The Birmingham Corporation was a local government body, and what it did was exercise its statutory powers in relation to a compulsory acquisition order, sometimes known as eminent domain, to take over the land for public development services. Under the law, compensation was payable to the business operating on the land for the loss of their occupation. Essentially, if you're gonna issue a statutory compulsory acquisition order over a piece of land, you have to pay compensation as a result of that acquisition. So you have to pay any compensation and also any damages for the acquisition as well. The court held that although the subsidiary company was the one that was occupying and it was running the business, the subsidiary company acting as the waste paper business on the land, it was only acting as an agent of the parent company. This is Smith, Stone and Knight Limited. So rather than talking about a situation in which we're looking at individual people like shareholders and directors, this is an example of agency theory applying to a company from a subsidiary perspective to a parent perspective. So therefore, Smith, Stone and Knight Limited was entitled to claim compensation for the loss of the business and of the land. The court decision was based on the reasoning that the subsidiary had no real independence from the parent company, and so as a result of which was acting, the subsidiary company was acting as an agent of this parent corporation. And so even though they were a separate legal entity, and even though that they had separate legal personality in law with them being separate companies, in substance it was merely an agent for the parent company. And it meant that the corporate veil could have been lifted, and therefore the parent company could claim compensation if it had directly ran the business itself. Agency theory requires a test to show that there is a lack of agency, or that there is using the company as an agent for your own personal gain, and this is known as the agency test. This is one of the major contributions that came from the case of Smith, Stone and Knight. This idea was a test that the court would apply to determine when a subsidiary could be considered an agent of a parent company. The court identified several factors which would assess and help them assess where such a relationship may exist. They are still relevant in English company law when it comes to whether or not there is a justification to lift the corporate veil on the grounds of the agency test. The parent company itself, the case, the company of Smith, Stone and Knight, was found to have direct and effective control of the business activities of the subsidiary. This control was sufficient to consider the subsidiary as acting on behalf of the parent company, and the profits that were generated by and as a result of the operations of the subsidiary company were treated as the profits of the parent company. And it is for that reason that the subsidiary was not acting on its own benefit, but it was acting for the benefit of the parent company. And then finally, the individuals who run the day-to-day operations of the subsidiary were appointed by the parent company. This indicated the subsidiary's lack of independent authority.